Good morning, Chair.
Yes, welcome.
Thank you.
Yes. Is the seat okay?
Yeah, it's okay.
It's okay? You're
Yes.
comfortable?
I'm comfortable, Chair.
Okay, we'll start with a quick round of introduction. My name is Martha Kome. I'm the chair of JSC, and I welcome you for this interview. Karibu.
Thank you, Chair.
Good morning.
Good morning.
Isaac Ruto is my name, also Vice Chair.
Thank you, Vice Chair.
Good morning, Your Honor. Jacqueline Ngutia, you're welcome and all the best.
Thank you, Commissioner.
Good morning, Mheshimiwa.
Good morning.
Caroline Zilani, Commissioner, you're welcome.
Thank you, Commissioner.
Good morning.
Good morning,
Charity
Commissioner.
Kisotu is my name. You are welcome.
Thank you, Commissioner.
Good morning.
Good morning, Commissioner.
Omwanza Ombati, karibu.
Thank you, Commissioner.
Good morning.
Good morning.
Njoki Ndongo.
Thank you, Commissioner.
Good morning, Your Honor.
Good morning.
Anthony Mwima, karibu sana.
Thank you, Commissioner.
Good morning, Mheshimiwa.
Good morning.
Fatuma Sichale, karibu sana.
Thank you, Commissioner.
Good morning.
Good morning.
You're welcome. Olwande Evelyn.
Thank you, Commissioner.
Morning.
Good morning.
Dorcas Odur, Senior Counsel and Attorney General.
Thank you, Commissioner.
Winfrida Mukaya, Secretary, you're welcome. I wish you well.
Thank you. Thank you, CRJ.
Thank you, commissioners, for that introduction. This is Honorable Yusuf Abdallah Shikanda.
Yes, Chair.
If you could start by telling us your county and your ethnicity.
My county is Kakamega. My ethnicity is Luya.
Very well. We will start the interview. We want you to relax and feel comfortable. The water in front of you is yours. We want to have a kind of a conversation with you so that we can get the very best out of you. If you could begin by telling us who you are and what has motivated you to seek for this promotion, what has distinguished you so that this commission will recommend you from among the 100 candidates we are interviewing. What achievements have you got in your career? What skills, what innovations? We are looking for serious men and women of integrity and moral probity who can work very hard in the High Court. The challenges we are facing in the High Court require heavy lifters. So we want to know what successes have you had where you have worked in terms of backlog clearance. Because if you have created backlog and mayhem in your previous station, then you are not the kind of a person we want to take to the High Court. So tell us who you are and what distinguishes you in 5 minutes.
Thank you, Chair. My name is Yusuf Abdallah Shikanda. Currently, I'm the senior principal magistrate and the team leader at Makindu Law Courts. Shikanda is an advocate of the High Court of Kenya. I have more than 17 years post-admission experience and more than 15 years on the bench. I joined the judiciary in 2010, and my first posting was in Malindi. I have worked in several other stations, and currently I'm the team leader at Makindu Law Court. Chair, if you allow me, Shikanda meets the constitutional and statutory provisions for being appointed judge of the High Court. And apart from that, Shikanda embodies the values and principles of the Constitution. Shikanda is independent. I always make independent decisions. I do not allow interference in my decisions. Shikanda has integrity. I'm a person of impeccable integrity. I've never had any issues of integrity for over the 15 years that I've been on the bench. Shikanda treats people equally as required by the law. Shikanda handles cases impartially as required by the law. Shikanda is competent and diligent in the exercise of my duties. And Shikanda has very good innovative skills, research skills, and analytical skills, as can be exhibited in my sample writings that I presented to the Commission. And as far as backlog is concerned, other than the traditional methods that are being used in the judiciary, I'm sure the Commission does not want to hear that, because that is known what happens in the judiciary. I have also innovated other means, such as, for instance, in succession cases, there is a requirement that once a grant has been issued, then the parties have to wait for 6 months before they apply for confirmation. I have exercised my discretion in such matters so that if there are no issues, there are no contentions in the matter, then I allow the parties to apply for confirmation before the expiry of the 6 months. And the other issue is citations. When parties file citations, I talk to them instead of now arguing out the citations, people filing responses and all that, and fixing the matter for hearing. I just explain to the parties that now this citation is about who is supposed to take out letters of administration. If a party has refused to take out letters of administration, I explain to them the need to take out letters of administration, because if they do not take out letters of administration, then the estate will not be administered. So I enable them to reach a consensus such that they now agree to file a joint petition, and we close the citation without having a hearing.
You use mediation skills,
yes,
to avert protest and all that.
Yes,
but
Chair.
There is an issue which I know my colleagues will pick with you, because yes, I thought the law of succession is the one that sets the period of 6 months within which to confirm the grant.
Yes, Chair.
So I want to know why you are circumventing the law by allowing them to have the grants confirmed before the requirement of the law, because that can be a future ground for revocation of that grant.
Thank you, Chair. The same law gives the court discretion, for good reason, to direct the parties or to allow the parties to apply for confirmation of grant before the expiry of that period.
So they have to bring another application under that provision for you to reduce the period? I
allow even oral applications.
Okay.
Yes, that, I do not insist.
My colleagues will pick it up. Commissioner Omwanza.
Thank you, Chief Justice. Your Honor, if you look at the Constitution.
Yes. May I?
Yes, yes. Article 29 provides for freedom and security of a person.
Yes.
And particularly Article 29F.
Yes.
Provides that that right includes a right not to be treated or punished in a cruel, inhuman, or degrading manner.
Yes, Commissioner.
So my question is, when can a punishment be deemed as cruel and unusual?
Punishments such as corporal punishment.
Corporal already is set out under E, 29E. So when can a court assess a punishment, and under what standard, and then declare it that it's unusual or excessive?
I'm thinking of a situation where a party is charged with an offense, and the law provides penalties for that offense.
Yes.
And treated or punished in a cruel or... Okay, I'm looking at punishment and treatment. Let's start with treatment. Treatment in accrual, if a person, for instance, is in remand custody, and while in remand custody, he is being tortured while he awaits for his case to be heard, that would be treatment that is cruel and inhuman. And it can also extend to court proceedings when the court, probably the court is not treating the parties fairly.
Yes.
That can also amount to cruel and inhuman.
Yes.
A court that may even go to the extent of insulting litigants. That is cruel and inhuman, in my view.
Okay. Now, under article, the same article,
Yes, Commissioner.
29 B provides that a person also shall not be detained without trial except during the state of emergency,
Yes.
in which case the detention is subject to Article 58. So how would a court in a state of emergency apply 29B? Does it mean that individuals then can be detained endlessly without a trial? And if not, what will be the what will be the application under Article 58?
Now, thank you, Commissioner, for that question. Under Article 58, a state of emergency may be declared, but that declaration should be necessary to meet the circumstances for which the emergency is declared. And if you look at Article 58, the state of emergency, or rather the declaration, cannot be indefinite. And even if it's extended, it cannot exceed 2 months from time to time. So if you look at Article 58(2), Commissioner, it says that a declaration of a state of emergency and any legislation enacted or action taken in consequence of the declaration shall be effective only for not longer than 14 days. So there are periods that are set by the Constitution. It cannot be indefinite.
Yes, the period that is saved by the Constitution is the period of the state of emergency.
Yes.
But under 29B, the proposition there is that a person can actually be detained without trial. So does it mean that in course of this state of emergency,
Yes.
in the criminal justice system,
Yes.
a person can actually be detained without trial until the entire state of emergency is complete, or it runs through?
No, my thinking is that if the circumstances allow, even during the state of emergency, then they can be tried. But if the circumstances are so dire that no trial can take place during that state of emergency, then unfortunately they'll have to be detained during that period when trial cannot be conducted.
Okay. And lastly, I think, I don't know whether you are the one that I've seen one or twice or two times write judgments in Swahili.
Yes, yes.
So what is the motivation for that? I've read a number of them, but they seem more complicated when you read them in Swahili than when you read them in English.
Well, if I start with the motivation is, thank you, Commissioner, the motivation is access to justice.
Yes.
Because most of the people that we serve understand Kiswahili more than any other language. And I started this when I was at the coast, and you know the coast, the language, the primary language is Kiswahili. So that is why I started writing judgments in Kiswahili, so that I can communicate better to the people that I'm serving. And on the second aspect, you
Yes.
say that they seem to be complicated.
Yes.
They seem to be complicated because we are not used to this language. We are used to the English language. But if you translate the English words that are used in the judgment to the Kiswahili word, for a person who understands Kiswahili and who loves the Kiswahili language, they will be able to understand.
Then how would you, for instance, apply doctrine or precedent in your judgment
Yes.
when you write them in Swahili?
Yes.
And how would you meet the ingredients of the charge that are set out in English in the
Yes.
penal code?
Yes.
Yes. How are you able to reconcile that?
Commissioner, I'll be able to reconcile because it's just a matter of language. It's just a matter of language. And wherever I write judgments in Kiswahili, there is always an English rendition. So it's just a matter of translation,
Okay.
interpreting and translating.
So which is the operative judgment? Is it the Swahili?
No,
or-
the English judgment.
Okay.
Yes.
All right. Thank you. That's all, CJ.
Thank you.
Thank you, Honorable Chief Justice. Honorable Shikanda,
Yes, Commissioner.
what is the language of the High Court?
The language of the High Court, previously, it used to be English. But I came across the High Court Organization and Administration Act, in particular Section 16. It says that the language of the High Court is English and Kiswahili.
I wasn't aware of that change because
Yes.
I was going to point out that if the language of the High Court is English, then you will have to abandon writing in Kiswahili.
Yes, I saw it in that act, Commissioner.
All right, okay,
Yes.
fair enough. Now, not too distant back, many of the cases from the Environment and Land Court were transferred to the Magistrates' Courts.
Yes, Commissioner.
You're aware?
Yes, Commissioner, I'm aware.
Do you yourself hear and determine land matters?
Yes, when I was posted to Makindu about a year ago, I started hearing land matters.
Okay. Then, the question of adverse possession. Do magistrates' courts have jurisdiction to hear and determine cases touching on adverse possession?
Thank you, Commissioner. There is a judgment of the Court of Appeal that says that magistrates do not have jurisdiction to handle matters to do with adverse possession. I just can't remember the citation, but I'm aware of that authority.
Is that the matter of Pauline Sugawara?
I think so, but I'm not so sure.
But is that a settled position?
Well, until the Supreme Court pronounces itself, I think that is the position that we are bound to follow.
But
as
what is the
law courts.
current state of affairs? Are there varying judgments as to whether the magistrates have power or jurisdiction to hear and determine cases of adverse possession?
There are varying judgments, but at the High Court level. I have not seen at the Court of Appeal.
All right. And what is your own view about it? Forget about the High Court, forget about the Court of Appeal.
I should forget about stare decisis and.
For now, for
Yes.
purposes of this interview.
Well, my opinion is this. Adverse possession is a claim for title to land, basically.
Yes.
The means of acquisition may be different, but it's a claim for title to land. And if the magistrate's court has jurisdiction to entertain claims for title to land, then adverse possession should not be an exception, in my view, provided the land falls within the pecuniary limit of the magistrate's court. They should be able to hear the matter. And my view is also buttressed by, there is a provision in the, I don't know whether it's the Land Act or the Land Registration Act, that says that if there is any provision that is inconsistent with that act that deals with land, then the provision in the act, in the Land Act, prevails over that provision. So the provision that is usually relied upon is the provision in the Limitation of Actions Act. So using that, I would say that magistrates should have jurisdiction to hear claims.
How would you marry that with the provisions of Section 38, subsection 1 of the Limitations of Actions Act that specifically provides that the jurisdiction when it comes to adverse possession is, the jurisdiction is vested with the High Court?
In fact, that provision also creates more confusion because it talks of High Court. It does not even say Environment and Land Court. I don't know whether it was amended, but the last time I checked, it says High Court. So if we were to follow that provision, it means then even the ELC does not have jurisdiction. It has to go to the High Court. But like I said, now the Limitation of Actions Act basically deals with limitations, and it's not a primary statute that deals with land. The primary statutes are the Land Act, the Land Registration Act, and the other acts. And the provision there says that if there's any law or provision of law that is inconsistent with that act, then it ceases to apply when it comes to land. That's how.
In terms of the Limitations of Actions Act and the Land Act, which is a latter statute?
The Land Act.
The Land Act. And what does the law provide when it comes to deciding when there is conflict between two statutes, which one should prevail? Is it the earlier one that was enacted, or is it the latter one?
Thank you, Commissioner. Well, there is the general presumption that the latter one should prevail, although it should specifically, if it's overriding the other provision, then it should specifically state so. But generally, it can be taken that the latter statute would prevail.
Thank you. So the position as it is now like we do not know whether magistrates should hear land matters specifically touching on the aspect of adverse possession?
No, the position is that for now, let's follow what the Court of Appeal says.
All right.
Otherwise, we'll be in trouble.
All right. Thank you. Thank you, CJ.
Thank you, Honorable CJ, and Mheshimiwa once again, karibu. I will take you to a criminal trial.
Yes, Commissioner.
And only one question from me. You must be aware that there are some instances where a trial can proceed in the absence of an accused.
Yes, Commissioner.
Like in which instance?
Article 50, Sub-Article 2, says that an accused person has the right to be present at his trial unless he has made it impossible for the trial to proceed in his presence.
Okay. Now, how can an accused make it impossible for trial to proceed? Like in what instance?
An instance that I would think of, particularly for accused persons who are in remand, at times they refuse to attend court. When their names are called out, they refuse to attend court. You issue a production order, they still refuse. Or another instance, although that one I cannot conclusively say that the court may proceed. I believe other measures can be taken. But the other incident is where an accused person absconds. He refuses to attend court totally. He cannot be found even after a warrant of arrest has been issued. He cannot be found. And in the interest of justice, and probably upon application by the prosecution, the court may direct that the matter proceeds. Another instance, accused person comes to court and he's totally unruly. He doesn't want the matter to proceed, shouting and, just being unruly, disorderly. Then the court can direct that the matter will proceed in their absence.
Okay, thank you so much. I wish you the very best.
Thank you, Commissioner.
Yes, good morning.
Good morning, Commissioner.
Are you articulate with the provisions of Order 40, Rule 4 of the Civil Procedure?
Well, I know the general provisions of Order 40. I'm not so sure about Order 44.
Order 40, Rule
4. They deal with temporary injunctions.
Yes, but I'm particularly interested in Rule 4. Are you familiar with Rule 4?
I'm not so sure of
Rule
what
4
it provides. Probably
provides for when injunctions can be had ex parte. Applications can be had ex parte.
Yes.
Are you familiar with that?
Yes, I'm familiar with that, Commissioner.
So kindly, can you tell us what conditions are under that order with regard to timelines, termination, and hearing of such applications?
Thank you, Commissioner. According to that provision, if the court hears the matter ex parte and grants an interim injunction, then that injunction will lapse for 14 days only. And in case there is an extension, it has to be by consent for a further 14 days, and it has to be once.
Timelines, hearing, I mean, how does it terminate? How can it terminate? There's also a provision on termination, automatic termination.
Automatic termination is if the injunction cannot be in place for more than 1 year. It will terminate.
There's a procedural requirement that if you don't adhere to, then it automatically lapses.
I think if the application is not heard.
What are the conditions with regard to hearing?
This has escaped my mind, Commissioner. It has escaped my mind.
It has escaped your mind?
Yes.
Okay, thank you, CJ.
Thank you, CJ. Good morning once again.
Good morning, Commissioner.
You're well?
Yes, I'm well.
Need some water break, but I know today it's a bit.
Yes, no, I'm fasting. So.
Yes. My apologies, I forgot.
No, it's okay.
Yes,
it's okay.
Okay, I've gone through your sample writings,
yes.
Your Honor. You shared decisions in criminal matters, that's robbery with violence, sexual offenses, pre-trial detention in the Shakahola matter, burial dispute, and a tort claim. Looking at all your sample writings, you are an officer who demonstrates strong doctrinal grounding, careful evidentiary analysis, and structured legal reasoning. They exhibit your excellent issue identification and disciplined method of linking facts into applicable legal principles. You also engage with statutory provisions and precedent in a sound manner. Your tone is measured, impartial, restrained, reflecting appropriate judicial temperament. Looking at the 5, you appear to be inclined towards purposive, pragmatic, and contextual, sensitive judicial philosophy. I don't know whether I'm right or wrong.
I agree, Commissioner, and a little bit of legal realism.
Okay, great. I'm particularly, I was impressed with the decision in the rape matter. The allegations were that the complainant was a person with mental disability, and you clearly were able to state what other courts in the Republic of Kenya are suffering from when you have conflicting decisions of the superior courts or even high courts. Particularly in this case is whether a victim of mental disability should be charged under the the offense should be, the accused person should be charged under the Sexual Offences Act or the Penal Code. Maybe you can just highlight to us your thoughts around it.
Thank you, Commissioner, for that question. Well, when I was faced with that case, I examined the Sexual Offences Act, and I found that there is no express provision that deals with the commission of sexual acts against persons with mental disabilities. There is Section 7 that was being misused by the DPP, and unfortunately some courts would entertain that talks of committing a sexual act within the view of a person with mental disabilities. That was being used to charge persons with committing acts against victims with mental disabilities. But I found that was not proper. Then I looked at Section 146 of the Penal Code. Initially, it used to talk of defilement of imbeciles and idiots, but fortunately, it was amended. Instead of idiots and imbeciles, it talks of now persons with mental disabilities. But if you look at that provision, it says that this should be in circumstances that do not amount to rape. And it's not so clear on which circumstances do not amount to rape. And if you look at the Penal Code, it does not also define who a person with mental disabilities is. So now you have to go elsewhere and look at the Mental Health Act and other acts that define that. So I also thought that Section 146 would not be appropriate, because now it talks of defilement. We have, if you look at the Sexual Offences Act, we have a different definition of defilement, so that defilement does not cannot suffice in those circumstances. And it also says that in circumstances that not amount to rape. But here, the allegation is rape. So I found that that was not appropriate. And when I looked at the authorities, most of them did not really deal with the issue of consent when it comes to a person said to be suffering from mental abilities. So now I had to look elsewhere, and I found the Convention on the Rights of Persons with Disabilities. So looking at it, there was the provision of non-discrimination. There's the provision that, you know, they are also entitled to enjoy the rights like any other person. They can form families. They can have legal consent, but we didn't have that in Kenya. And now I examine the issue of mental disability, then I say that we cannot have a blanket definition of mental disabilities, because there are different categories when it comes to mental disabilities. And we have some disabilities that are not even permanent, they are temporary. For instance, if you have PSTD, that is temporary. So we cannot group everyone together and say that these are persons with mental disabilities and therefore they lack capacity to consent. There are those who, when they're in their lucid moments, they are aware of what's happening, you know, they know what's going on, they are able to appreciate the nature of that act that is complained of. So if this person is able to appreciate the nature of that act, then why would you just say that they do not have capacity to consent? Then I say that now this issue of consent has to be really examined, and it depends on the circumstances of the case. And that in that particular case, I found that she was able to agree or refuse. And the evidence indicated that she did not consent to whatever was done to her. Because even this was a woman who is married, she has children, she has a husband. So how do you say she already has a family? Now how do you say now she has no capacity to consent?
Yeah, you are able to look at other things, the force and
yes,
other things to establish that.
And if you allow me, Commissioner, just one last thing.
Yes.
I delivered that judgment on the 8th of May 2025. I delivered the judgment in the morning. Now in the afternoon, I read in the media that the President had assented to the Persons with Disabilities Act 2025, the same day. And when you look at the act, the issues that I was raising that judgment were actually taken care of in that act.
Okay.
Yes.
Thank you. Thank you. I commend you for that.
Thank you, Commissioner.
CJ.
Question?
Yeah.
Yes, Commissioner.
Just following up from what Commissioner Ngutia raised, when you say that a person with mental disability, did I hear you say that a person with mental disability can actually consent?
Yes, my point, Commissioner, is that there are degrees to that disability. We cannot group them all together that these are persons with mental disabilities. There are those that are able to appreciate the nature of that act that is being complained of. And they are able to say no, they are able to tell that this is bad, I don't want this. So it depends on the facts and circumstances of the case.
And what if that disability is not something that they were born with? What if it is a disability? Because I heard you say
yes,
that this was somebody who had given birth.
Yes.
So that, in your view, meant that they would be able to appreciate certain things. What if that disability developed even after they gave birth? Wasn't that necessary to consider?
Sorry, Commissioner, that was not the reason as to why I found that, you know, she was able to consent. I examined her evidence. She was able to appreciate the nature of what was done to her. She knew the accused person, even by name. She knew the accused person's home. And her evidence was corroborated by the other witness, where she was found and in what state.
But can't a person still possess that, be able to identify a victim, know their home, and still lack the competence, mental competence?
Yes, I agree with you, Commissioner. That's why I'm saying it depends on the degree of disability. So we cannot just have a blanket rule that all persons with mental disabilities are incapable of consent. That is my argument, Commissioner. We have to look at each case and examine the circumstances. Then we can now make a finding, no, this one is unable. And
is that an examination that a court competently can make, or do you need an expert, a doctor, to be able to make that assessment before you look at all that? Isn't it necessary first to have, maybe a psychiatrist look at this?
I agree, Commissioner.
And in this case, was that done?
There was a report.
Oh, okay.
Yes.
All right, thank you.
Thank you, Commissioner.
Just following up from there, I think I was also concerned that there was a medical report which you then chose to disregard. And I was curious why you did that. And then you then went to conclude, looking at different comparative case law, making your own conclusion. But I don't know why you found that the medical report that said that she was mentally incapacitated was not sufficient.
Thank you, Commissioner. The medical report was from an expert, and according to the law, the court is not bound by expert opinions. That is one thing. And secondly, Commissioner, yes, I looked at the report, but the report was not explicit that, she was totally mentally disabled. It indicated that she had a mental disability. And now, I examined the evidence, the manner in which she gave her evidence, because the issue that I was dealing with, Commissioner, was the issue of consent. Was she able, in the circumstances, to appreciate the nature of the act and know that she can say no or yes? Because her evidence was clear that, she was forced to do whatever happened to her. So if this person appreciates that you can be forced to do something, then this person knows that you can either accept or be forced to do something.
Okay, thank you. I think we look for each other, then we can follow up that discussion.
CJ,
thank you, Commissioner.
A follow-up question. I also actually wanted to ask whether the issue of disability is a judicial matter or a medical matter, and how a court can depart from an expert if you do not have another expert opinion which is assisting you to depart from the medical report that you have. But further to that, don't you think that the provision as it was actually protected? Because the path that you are taking is actually making the victim vulnerable. Because
sorry, Commissioner, the provision, I'm not sure which provision you are referring to.
The provision of disability,
yes,
or mental incapacity,
yes,
and therefore not being in a position to consent, protects the victim, than opening the path saying that there are instances where somebody with mental disability can actually consent. And secondly, I wanted to know from you had said that the DPP was abusing some section. Please just clarify which section and how the DPP was abusing the section.
I will start with the last one, Commissioner, and I apologize, probably I used the wrong words. But what I meant was Section 7 of the Sexual Offences Act that says that a person who commits sexual acts within the view of a child or a person with mental disabilities commits an offense. So the DPP was using that particular section to charge victims of sexual acts who have mental disabilities.
How many cases did you come across that they had done that, and where?
Very many cases. Some came to me. But
how many? How many?
I cannot tell the number, Commissioner. But the good thing about me, I do not let it just go. I tell them this is wrong, amend. then they amend.
So you don't
I do
remember
not wait for the hearing, then I dismiss the case. No. I tell them this is a wrong provision, reflect on this and amend.
You can't remember the number.
No, there are many cases, Commissioner. I cannot recall the number, but there are many cases. And even from the authorities that I went through, that was the position, where now the High Court was reversing those decisions based on that.
On the grounds of abuse, on the grounds of wrong application of the
Commissioner,
of the
sorry, I
sections?
withdraw the word abuse. I withdraw that.
Actually, both the Commissioner Omwanza and the Attorney General have asked the questions I wanted to ask. Yes, thank you.
Thank you, Chair. Good morning, Honorable Shikanda.
Good morning, Commissioner.
You've gotten us off on a very interesting start.
Yes.
But I want to commend you for your courage, for treading the unbeaten path, because that area really needs to be looked into, because I've always wondered also, when you talk about someone with mental health issues, for example, how far do we go? You know, you could be suffering depression, as you say, PTSD. How far do you go so that you draw the line and say from this point, then it becomes an offense? And I like your approach. You may be wrong, you may be right, but that is how the law grows, so I commend you for that.
Thank you, Commissioner.
Another interesting thing I noted is your professional affiliations. I see here you're an honorary researcher with the International Federation of Neurological Sciences. That is so off what you do as a career. I was just curious, what does this entail, and what is it that interested you into going into
thank you, Commissioner. It's actually not off. Neurolegal science examine the intersection between neuroscience and the law. And neuroscience is the study of the nervous system, but more particularly the brain. So when you examine the brain, and that has to do with now mental capacity and all that, so that when you are dealing with an accused person, you don't just, particularly when it comes to sentencing and other steps that you may take, whether to divert or not, you don't just look at the act and what the law says. You also examine.
I see the connection.
Yes.
Now. Very interesting. So maybe we can now go to the questions I needed to ask you about. Basically, I wanted to engage you on your performance. From the report, I'm assuming you've seen a copy of this report.
Yes, I received the report, Commissioner.
Is it accurate?
It's not accurate.
Okay.
Yes, and I communicated to DSPOP. I even sent them the evidence.
In what respect is it not accurate?
If I'm to concentrate on July 2025 to December 2025,
yes,
a report indicates that my judgments are 50, but they are actually 54 instead of 50.
That 50, the figure of 50 that I have here is for the period, the first half of this financial year.
Yes, that's what I'm talking about, Commissioner.
So you are saying there ought to be 54
there
and
ought
not
to
50.
be 54 judgments, not 50.
Okay.
And of course, there are other discrepancies in the preceding periods when I was in Shanzu and part of Makindu. Because when I was posted, or rather transferred to Makindu, I carried some judgments. And when I wrote the judgments and sent them back, now they were actioned to the person who delivered the judgments, but they were my judgments. About 23.
Okay, I hope you've engaged this POP and they're going to correct that.
Yes, I engaged them. I've been following up, but I haven't received any feedback from them.
Okay, for the period, the same period you said you had 54 judgments, not the preceding periods, but the period you said you had 54 judgments.
Commissioner.
Essentially, for your personal performance, I think it's good, even without the extra 4.
Yes.
I see here you are doing 22% out of the expected 20, so you're exceeding expectation, and your overall performance is at 110%. But the issues of concern, also your backlog situation is not so bad. 5% of your matters are backlog, 95% are current, which is good. The areas I had concerns was the case clearance rate, which is below the national average. You are doing 100, essentially just clearing what you have received and not tackling backlog. And also more concerning is the court productivity, which is quite low at 247 against the national average of 370. I don't know maybe what you have to say about especially the court productivity.
Thank you, Commissioner, for that question. During that period, July to December, in fact, all my colleagues took leave, of course, at different stages, but they all took leave during that period. So that's why the productivity was low. I was the only one who stayed until December. No, I also took leave, I think, sometime in August. Then I came back until 29th of December. So all of us were on leave at different times during that period. And the other thing is that we have 2 small claims court. So that data does not consider the small claims court.
Oh, okay.
Yes. So they do a little bit of what we do, and of course they have their matters in the small claims court. And the other thing is that at Makindu, we do not have power backup. So that when there is a power outage, we cannot do the virtual hearings. We cannot do other things that require us to use the CTS.
Are you on the solarization list? You're the head of station, right?
Yes.
So I suppose you would know. Are you on the solarization list for this financial year?
Yes, I was told we were on that list because I followed up with the CRJ's office. I wrote to them, and of course they explained why we didn't have the solar system and all that. But I was informed that we were on the list.
Oh, okay. Okay, thank you, and I wish you well.
Thank you, Commissioner.
Thank you, Honorable Chair, and welcome again, Mheshimiwa.
Thank you, Commissioner.
The judiciary receives a constrained budget allocation. Could you tell us what innovations you will employ to dispense justice within a constrained budget?
Thank you, Commissioner, for that question. I always believe in simplicity. And it starts with the judicial officer as a person. So if a judicial officer is wasteful, then it's likely that the others will also be wasteful. So what I do as an individual judicial officer, I try so hard. If it's judgments, I type them, but I post them on CTS. I do not print them out. So that if a person wants a judgment, they go to CTS. But if a person is unrepresented, then we make arrangements for them to be supplied with the judgment. And we do not print out all the documents that are filed on CTS. We do not print them out. If a judicial officer needs to access the document, then they just need to go to the CTS. And when it comes to budgeting also, we are very deliberate on what we budget for and for how much. We are not usually wasteful when it comes to budgeting. And same thing applies when it comes to, for instance, electricity. I always ensure and advise people that if a room is not being used, switch off the lights, switch off the fans, so that we do not have high electricity bills. So those are some of the measures that I take to ensure that resources are used prudently.
Okay. You also said that in your introductory remarks that you are a person of high integrity. Could you just tell us the measures that you've put in place to promote an ethical culture?
Thank you, Commissioner, for that question. We have an integrity committee at the station. Although the activities of the committee are usually hampered when we have transfers of people from the other stakeholders within the committee, but we have the integrity committee, and we also have a quality assurance officer at the station, and we have a complaints box where if there are any complaints, people, the litigants are allowed to put them in the box, whether anonymously or not. And we also have morning briefings. We have a duty roster for that. So we tell people that you are not supposed, if you pay for any service and you are not issued with a receipt, then just know you are being conned, and that we do not accept cash. So if you are paying anything in cash, just know that you are being conned. And I also encourage them, if there is any issue, I allow them, even when I'm in court, raise up your hand and say. If somebody is asking you to pay for any service, just raise up your hand. I will listen to you and we will deal.
Thank you. I wish you all the best.
Thank you, Commissioner.
Thank you, Honorable Chair. I have 2 questions for you. Are you involved in CUC activities?
Yes, Commissioner.
Okay. So how do you incorporate stakeholder feedback into decision making without compromising core principles?
Thank you, Commissioner. Stakeholder engagement, it's part of the principles of STARG. And if there is anything that is supposed to be done that affects the stakeholders, we usually discuss. We discuss as a CUC, and then when we reach resolutions, we implement them, and we communicate to them that we've implemented the decisions.
Okay. What is the role of a mentor? And maybe if you could share an example of a successful mentoring relationship that you've had and its impact on the mentee or on yourself.
Thank you, Commissioner. I take mentorship as a tool for growth, and a mentor is one who inspires the people that he works with or the people that he relates with. I'm using he to mean male or female. And one successful story is, for me, I can mentor anyone. It doesn't really matter whether it's a JO or a member of staff. When I was in Malindi, we had cases that dealt with narcotic drugs. So what used to happen is that they used to arrest people, and investigations were not thorough and bring them to court. So you would find that most of their cases were being dismissed, they were being thrown out, and drug abuse is a menace at the coast. So what I did, I arranged, of course, under the auspices of the CUC. So we had some training of investigators. We called people from outside, and I also volunteered on a topic, so we trained them. So after that, then they started to do thorough investigations, and they had success in convictions and all that.
So is that the experience you have in mentorship?
That is one of the experiences.
Okay.
Yes.
So, but that was a one-off. It's not continued.
Well, when you are transferred to a different station, there are now different challenges. From Malindi, I went to Machakos. Machakos, we didn't have cases of drug, but now we had wildlife crimes, and I did the same thing with wildlife crimes.
So you drop your mentees anytime you're transferred, you go move on to the next?
No, I don't drop, Commissioner. I don't drop.
Okay.
Yes.
All right. Thank you, and I wish you well.
Thank you, Commissioner.
Good. I can see you are exploring new horizons. Not a bad idea.
Thank you, Commissioner.
Can you tell us a situation involving conflict management that you have experienced?
A situation in which I've experienced conflict management?
Yes, maybe you are conflicted in some way.
In terms of my duties, I can't remember any conflict, but in terms of conflict in the ordinary sense, at the station, yes, there have been conflicts. As the HOS, people will come and report to you that so-and-so has done this, so-and-so has done this. So I have experienced that, Commissioner.
Would work on solving any problem in the world, what problem would it be?
Thank you, Commissioner, for that question. The problem that worries me the most is the degradation of the rule of law all over the world. Respect for the rule of law is declining. And when that happens, there's usually a lot of anarchy, and people even lose trust in institutions such as the judiciary. So that is one thing that I would really want to fix. Because if now people observe the rule of law, then these other things are likely to fall in place.
Thank you. Thank you, Honorable CJ.
Thank you, Commissioner.
CJ, one follow-up question. Can you give
Yes,
us
Honorable AG.
one example of how you can fix the rule of law globally?
Thank you, AG. Well, my opinion is that you can't just start globally. You start with where you are. Yes, you start with where you are, and that happens as a judicial officer. It happens when you deliver judgments. Now, if I happen to go to the High Court, I can say it's the constitutional court. So if you enforce the rights...
I agree. Thanks. It's okay.
Yes, you start small and then move global. Thank you very much. Mheshimiwa, I was looking at your papers and I was attracted to your degree, which you obtained from the University of Zanzibar.
Yes, Chair.
Bachelor of Law and Sharia.
Yes, Chair.
So you can also be a Qadi because you are learned in Sharia.
Well, yes, I have knowledge in Sharia law, but the other requirement of being a Qadi, you need to speak the Arabic language. I'm not so good at that language, so that would definitely kick me out.
Okay.
Yes, and I've not been practicing Sharia law for a very long time. In fact, since after the decree, now I moved to this other domain where now I'm dealing with this other aspect of the law and not Sharia.
Because it's stated to be a Bachelor of Law and Sharia. Was
Yes,
it equal when you studied? You studied both the common law and
yes.
and Sharia law in
Yes,
equal
Chair.
measure?
Yes, Chair.
Okay.
But predominantly, it was this other domain of the law, not the Sharia.
Okay.
Sharia, it was just a few aspects of the Sharia law.
Okay.
Yes.
Very well. I think this brings us to the end of this interaction with you, Mheshimiwa. And we always give a candidate an opportunity also to engage us. So the floor is yours.
Thank you, Chair. In the spirit of Article 7 of the Constitution that declares Kiswahili as the national language, and I've also mentioned Section 16 of the High Court Organization and Administration Act, I seek your permission to, at this point, to address the Commission in the Kiswahili language.
Very well.
Thank you, Commissioner. Mwenyekiti wa tume na wajumbe wa tume, kwanza na ningependa kutoa shukrani kwa kuweza kuorodheshwa kwa ajili ya haya mahojiano. Ni nafasi nadra ambayo sio kila mtu ataipata. Kwa hivyo nachukulia kwamba ni jambo la heshima mimi kuwa hapa leo. Na pili, pia nashukuru kwa muda wenu kwa kuweza kunialika hapa kwa ajili ya mahojiano. Na nikiangalia, nikitathmini haya mahojiano yote, naona kwamba tumezungumza vyema. Huenda ikawa kuna maswali yamenipiga chenga kidogo, lakini yote ni kawaida. Haimaanishi kwamba labda sifai. Mimi nimekuwa mtoto wenu kwa zaidi ya miaka 15. Tabia zangu mnazijua kama tume, kazi yangu mnaijua kama tume, na naamini kwamba kwa muda wote huu mikono yangu hii nimeikosha na nipo tayari kuketi na wazee. Naahidi kwamba tume ikiona vyema kwamba niweze kupewa nafasi hii, Na kufikia hapa naomba, labda wengine wamekuwa wakija hapa hawaombi kazi, mimi naomba kwa heshima kuu, naomba tume kwamba niweze kupata hii kazi, na sio kwa faida yangu tu. Nikiweza kuteuliwa itakuwa ni kwa faida ya wananchi wa Kenya. Maana sitaki nijifaidishe mimi tu. Nataka niweke katika ile nafasi ambapo maamuzi yangu yatakuwa na athari yenye manufaa kwa wananchi wote wa Kenya. Na nawaombea kwa Mwenyezi Mungu kwamba awape hekima, awape busara na muwe na siku njema. Asante.
Thank you. I think you have done very well. You've done very, very well. I've been following your Swahili judgments as well. There is also another candidate who tried. Yes, and you've done very well. So we wish you all the best on behalf of the commissioners. We
Thank
wish
you,
you
Commissioner.
success. We'll get in touch with you when we complete this very competitive exercise. But we always like to encourage our candidates, like you have said, you are working for Kenyans, to continue doing the very best for Kenyans.
Thank you, Chair.
You are released.
Thank you,
Take
Chair.
our greetings to the people of Makindu.
Thank you, Chair, and thank you, Commissioners.